Normally on Fake Guru Fridays, I bring on a guest, another YouTuber who has a fake guru that they would like to present to my channel, and you get my reaction. I normally don't do a lot of research individually on the subject person because I want the YouTuber, my guest that's coming on the show, to present me with the information so that my audience can get my real reaction to the information. And that is exactly how it was going to be tonight with my guest, Chief X. But here's a little life lesson, people. This is his son. This is his son right here. So when DJ Vlad said that Dr. Sebi is as much as a doctor as Dr. Dre, y'all was ready to take his head off, right? Y'all was going to take his head off. You going to do the same with his son? Y'all going to play fair? Right? All I want to do, I just want y'all to play fair. Just play fair. This is his son. Listen to what his son says.
Good. By the USHA Herbal Research Institute.
Because we're not doctors, right? When we talk about Dr. Sebi, that's a moniker that was given by the people, just like we have Dr. Dre, right?
Because we're not doctors, right? When we talk about Dr. Sebi, that's a moniker that was given by the people, just like we have Dr. Dre, right? When we talk about Dr. Sebi, that's a moniker that was given by the people, just like we have Dr. Dre, right?
These are the things that Sebi and his whole team agreed to. This is the things that they agreed to. Number one, claiming orally or in writing, directly or by implication, that respondents, their services or their products can cure, mitigate, or in any way relieve or alter the course of AIDS, herpes, leukemia, sickle cell anemia, lupus, or any other human disease, pain, injury, deformity, or physical condition. Sebi agreed that he could not say or print directly or indirectly that he could cure or even ease pain of any human condition.
I'm licensed to practice in New York and New Jersey since 2010. New York has a very different type of naming convention for their court system. The fact is that the New York's Supreme Court, what they call their Supreme Court, is actually their lowest court. It's their trial level. It is not their highest court. The highest court in New York is the Court of Appeals. The New York Court of Appeals. So I want to get that out just to show a lot of those folks that you were showing in the video earlier how deceptive and misleading that they were by saying, "Oh, he won in Supreme Court."
Supreme Court, that's pretty high, right? That's what said.
Because any layman any layman who says here's Supreme Court, they automatically assume U.S. Supreme Court, not just the state Supreme Court, a U.S. Supreme Court. Right. Usually you specify, oh, it was a Wisconsin Supreme Court or etc. But New York's Supreme Court is its lowest level. It is its trial level. It is not the highest court in the state. They came to the table first.
It wasn't like they were offered a deal. No. They said, "Hey, listen. What can we do to get this?
To get out of this." So not only did they not go to a Supreme Court, they didn't win in front of a jury. The jury never went back to deliberate.
I want to bring someone else up. This is someone I recognize the name because they hit me up in the email. And they actually were one of the people who sent me this document that we're reviewing right now as a piece of the evidence. So I'm going to give him an opportunity because he was extremely cordial in his email. So I'm bringing Petar, P-E-T-A-R. I'm not sure how you pronounce that, but I'm going to bring you up and give you an opportunity to say your piece. So what's going on?
Greetings. My name is Petar Vukotic.
Petar, gotcha. Okay.
JT, congratulations on the success of the show, man.
I appreciate it. Thank you.
And I also want to say I just love the premise of this show because JT offered $10,000 to anybody to bring the evidence of Dr. Sebi's acquittal, right? If you go to page 9 real quick of that court case that you just pulled up from 1988,
okay,
it will even tell you that Ma'ab Bowman and Alfredo Bowman were ordered to pay $900 in court costs. That means they lost the case. When I sent you the 1988 civil case, I had told you that was just one of the cases.
Okay.
So the two cases in question here are the 1987 criminal court case,
yes,
in which Alfredo Bowman claimed that the court agreed that he was able to cure AIDS. And you also have the 1988 civil case where they told him you can't say you cure anything, right?
Correct. You got my interest now, man. You got people on the edge of their seats. They on the edge of their seats. Am I gonna lose this money?
I've seen this.
The money. That's right.
I'm gonna lose this money. Let's go. Let's say, if I lose this money, that means this is gonna be one of the hottest videos ever. Let's go. Let's do it.
Well, I don't know if you, JT, I don't know if you remember what I told you in the email, but I said, hey, I'm not even interested in the money.
Man,
I'm just interested in presenting the truth.
If you present this truth, someone's getting this money. I don't care. It's leaving my hands. Let's do it. All right, let me see.
In this article, it says, the charge of dispensing medicine without a license has already been addressed and defeated in civil court. Sebi's attorney, Simeon Greenaway, a black man, says he's proud to have representing him. Said the more serious charge of practicing medicine without a license was to have been heard in May, but it was postponed to September 27th in New York State Supreme Court. So what ends up happening is, even though the criminal case was started in May of 87,
right?
The civil case ends in 88. And the criminal case is actually postponed to after the civil case. The research that confirms many of our findings that there is a direct correlation between nutrition and certain pathologies are articulated in the recent released Surgeon General's report on nutrition and health. This is Sebi speaking.
All right, let's go. All right. Let's go. All right, okay. I'm up now. Let's go.
Sebi adds, he says,
yes,
Abrams, the Attorney General, is trying to scare black folks into the closet of bad nutrition. I don't have to ask them for permission to say that I cure AIDS.
Okay.
If an individual, mind you, this is after the 1988 civil
real quick, Petar. Real quick, Petar. I just want to be clear. Are you presenting to me as evidence that the fact that Sebi did not actually do with the agreement? So he made an agreement that he could not say that he could cure AIDS. And you're presenting evidence to me that after he made that agreement, he then said he can cure AIDS? Is that
immediately
the basis of your evidence? That this man actually didn't conform to the agreement that he made?
Immediately after the agreement.
Right. Immediately after the agreement, he's like, forget that. I'm not doing it.
Immediately after it.
Even though I signed a piece of paper and I went to the judge saying, hey, please, let's get this over with, and I'll agree that I won't say it. Even though I signed that agreement, immediately afterwards, I'm not doing it. That's what you're saying.
He says, I don't have to ask them for permission to say that I cure AIDS. If an individual is capable of performing a particular feat, if he can do it, say it. They don't shut me up, he stated. Some people in your audience might recognize me as the Serbian Rasta from Dagger Squad University.
Oh, I remember. I knew you looked familiar.
So you're a funny guy, but honestly though, the reason I was
So is that the evidence?
No, I was going to explain what the fascination with our church and Dr.
Oh, come on, bro.
Sebi
No, we can't do this. We can't do
Peter
this.
trolling us. He's trolling us. You're trolling us, Peter.
Yeah.
No.
It's too
No,
much.
I promise
Listen. Listen.
Because I contacted
Okay.
the State of New York Office of the Attorney General
Gotcha.
to request the court documents. Okay.
All right.
Nick Cannon didn't do this, and no disrespect to Nick Cannon. You know, I know he's a lupus patient. You know, and Nipsey Hussle didn't do this. R.I.P. No disrespect to Nipsey Hussle.
All right. So what does this letter say?
So this letter says, and I'm so glad you have an attorney on the panel.
Yeah.
Because I've even spoken.
Because I know exactly what this is. It's a FOIL request.
Yes, exactly.
Okay.
Freedom of Information Law request, and
Okay.
I've spoken to attorneys in New York.
Okay.
To no avail. The Attorney General is Letitia James. She is the current Attorney General in New York.
Got it.
I don't know if people remember her from 2019. She tried to file a lawsuit to dissolve the NRA, but that's a whole different topic.
All right,
So
let's keep it moving. Let's keep it moving, man. Come on, keep it moving. Where we at?
So
baby,
this is what they tell me. They said, you requested the complete court records from proceedings brought against Alfredo Bowman, who was also known as Dr. Sebi, and who operated Usha Herbal Research Institute in 1987, which is the criminal, and 1988, which is the civil case.
Yep, I see that.
So it says the records access officer disclosed 11 pages of responsive records. She further advised that she was withholding other responsive records in their entirety under Public Officers Law, non sequitur 87-2A, and Criminal Procedure Law, non sequitur 160-50 and 190-254.
All right.
You administratively appeal the records access officer's determination, arguing in essence that the public interest supports disclosure of the withheld records. So what I did was, because they told me we're not going to give you access to those records, I start a petition on change.org for the Attorney General of New York State to release Dr. Sebi.
Can you go back to your
the
letter, because it looked like it wasn't done. They didn't say.
It's not done. There's a little bit more there. So
right, let's flesh this out.
Right. So it says the provisions of criminal. This is their explanation to why they would not provide the 1987 court record. It says the provisions of the criminal procedure law upon which the records access officer relied mandate that these records be withheld, precluding the records access officer from exercising discretion to disclose records that can be withheld. Specifically, criminal procedure law non sequitur 160-501C requires that when a criminal action or proceeding against a person terminates in that person's favor, such as by acquittal, the official records and papers relating to his prosecution on file with the prosecutor's office must be sealed and not be made available to any person. And criminal procedure law non sequitur 190-254A forbids the prosecutor from disclosing the nature or substance of any grand jury testimony, evidence, or any decision, result, or other matter attending a grand jury proceeding. Consequently, the withheld responsive records cannot be disclosed through a FOIL Freedom of Information Law request. You would need to obtain a court order. Key here, you would need to obtain a court order to have the records unsealed.
Okay.
This is a final agency determination. Please be advised that judicial review of this determination can be obtained under Article 78 of the Civil Practice Law and Rules. Now, anyone can bring a FOIL request, right? It's not that I'm special or I'm an agent or something. Anybody can request these documents.
Yes.
And then also file an appeal and go through an Article 78 Civil and Practice Law Rules procedure, right?
Petar, I think you trolled us for 30
I'm not trolling. because the answer.
No, real quick. Do you have said documents?
If you offered $100,000,
yes or no?
No one can get the documents by
Okay,
law.
So this is what you can do. Well, no, you just showed that there's a way that you can by court
There's a way
order.
to do
So
it. I don't live in New York. I don't live in New York.
Petar, listen,
I can't.
this is what you can do. Get the court order, come back, and maybe we can try this again. I appreciate your attempt, but you don't get it on this one. Try next time.
I think he's trying to imply that the evidence that breaks this whole shit wide open is buried into that criminal case. And because nobody can get it, therefore, it's all a conspiracy. They don't want the truth getting out, yada, yada, yada. I think that is the angle that they're going with, that because he was acquitted and the evidence that breaks the whole thing wide open is in that criminal case, but apparently not in the civil case.
Not the civil case, where the civil case is directly pointing to the fraudulent claims.
I knew when I seen the shades, it was some conspiratorial stuff. You can't trust people with shades because the eyes are a window to the soul. It's shady.
My closing remark is kind of directed at a bit of the chat who kind of want to say, oh, this Petar guy still deserves the money for some reason. And I want to say, JT was very good at being very specific about the wager. He wanted the court case, and the fact that his criminal case is sealed, you guys are making the presumption that the evidence is there. I'm not his attorney, don't get me wrong, but I'm going to say that JT is under no obligation to accept your presumption that whatever is in that sealed record is proof. He's under the onus is on you to provide it. He said the wager very specifically, very succinctly. The onus is on you to go get it. It's not JT's problem that the court record is sealed. It's on you to go to the extra mile and get it for yourself, and then you can recoup those court costs with JT's money.